petition under order 8 rule 1A3 with regard to receiving of documents with condonation of delay. My lords,
Come to para 6. Come to para 6 of the
further the petitioner has not provided any explanation for delay in filing the petitioner.
para 6 of the impugned order. Page 6.
I am reading that only, my lords.
On a perusal of the material on record,
This court
this
observed that.
court observed that the petitioner has not filed any petition under order 8 rule 1A3 with regard to receiving the documents with condonation of delay. Petitioner has not provided any explanation for the delay in filing the petition for receiving the documents. Now, this is something important. You have not mentioned anything about the documents in the counter file before that.
My lords, that were later found out, my lords.
Matter.
Father and daughter.
Obliged.
Letter.
Yes, Your Lordship. I'm the proxy counsel on behalf of petitioner, Your Lordship.
That's it.
My lord, it is admitted fact that the deceased had died intestate, and so Hindu Succession Act applies, and also it is admitted fact that deceased was the son of appellant, because of which she is class 1 here and is entitled for the share in property.
Come to para 90.
9 of.
Just read from the 5th line. You are the plaintiff.
Yes, my lord.
You instituted the suit.
Yes, my lord.
Defendants didn't appear.
Yes, ma'am.
Suit dismissed.
Defendant appeared, my lord. I didn't appear in the examination as a witness.
So defendant didn't appear in the appeal.
And he didn't appear.
Come to para 9
Of
the impugned order.
Yes.
Read the 4th line. The burden of proving the issue
Framed on the burden of proving the issues framed by the trial court was on plaintiff, but she could not appear because she died, my lord.
Continue, na?
Yes, ma'am.
The grounds
taken by plaintiff in her plaint and documents relied upon has not been produced in evidence.
What is the High Court trying to convey? We couldn't understand. What is it trying to convey? The grounds taken by the plaintiff in her plaint and the documents relied upon have not been produced in evidence. Plaintiff was given several opportunities by the trial court to produce evidence in support of the facts mentioned in the.
Yes,
then who appeared on behalf of the plaintiff?
nobody appeared, ma'am.
So how do you expect the court to decide the suit? On the basis of what?
Yes, my lord.
Tell us, sir. Dismiss, next matter.
My lord, may kindly.
Yes. That's again. What's your good name?
Mayank Kumar Chaudhary.
Heard Mr. Mayank Kumar Chaudhary, the learned counsel appearing for the petition. This is a litigation between mother-in-law and daughter-in-law.
Yes, my lord.
Ajit Kaushal comes as LR of
Yes, my lord. Or of
his
appellant.
mother.
Of
Your
appellant.
case is the mother's share
Yes, my lord.
from the son's estate
Yes, my lord.
should come to him also.
Or section 15 of Hindu Succession Act.
But you should not, as brother said, nobody got into the box. But only the just
When did the lady die?
Died on 1st of February 2018.
1st February
2018. When appeal was pending, my lord.
Ah, that's the thing.
nothing.
Since this is a dispute between family members, we want them to sit, talk, and try to reach to some amicable settlement, right? Parties are issue notice,
Yes, ma'am.
take the notice.
All right.
Huh? Delay gone.
May it please, my lords. My lords, here, my lords, has succeeded before the trial court, my lords. The suit was decreed, my lords, for 13 lakh 50, reduced to 2 lakh 82, my lord. What the High Court says, you have not given the number of hours, my lords, but he's here. But my lord, there's a detailed reason. My lords, can you refer it to mediation if something can be worked out? This I was just thinking.
This causes a lot of embarrassment. Mr. Kamal.
I know that. I've told him, my lords, leave it to my lords.
Dismissed.
Very
Next.
well.
Judge, this is also Tola.
Tola.
Very grateful.
This is a case where the petitioner was unrepresented before High Court because the earlier counsel who has handed over the files to the client could not intimate him about this particular petition. So he was unrepresented. My humble submission that he may be allowed to represent before the High Court and put his case on merit.
Come to para 9.
In view of the aforesaid backdrop, the admitted position that the appellant plaintiff is the owner and landlord of the premises in question, the subject property is of commercial nature and had been let out to the respondent with effect from 1st November 2017 in terms of registered lease deed. That is fine. I have challenged 10. It is manifest that the respondent has failed to vacate the tenanted premises despite service of legal notice dated 30th October 2020. The appellant plaintiff being the owner as well as the landlord of the subject property is entitled to reap the benefits of his property and derive rent plus damages means profit for the wrongful occupation of the said premises by the respondent.
Now 11, 70,000 rupees per month from 17 to 20.
My lord, my case is this, that I have challenged this
You have
lease deed.
deposit 92,575
Yes, it was an order.
from 1st of March and at the rate of 1 lakh for each successive calendar.
My lord, my case is this,
You want
that
to stay back? You want to retain the possession?
I'm in position being, I have paid the part consideration amount.
Comply with this. Dismissed. Next man.
The issue is pending, my lords, in Otis Medicare. Big batch of
Tag
matters.
it.
Very good.
May it please, your lordship. Lordship, it is not only my case, it is even the respondent case that your lordship, I was in the position from 1987. The Honorable High Court in paragraph number 26, your lordship, it's made a completely contrary observation.
Para 21.
Yes, your lordship.
Bala Singham.
Yes, your lordship.
Bala Singham
Yes.
was the owner of the property.
Balasingham is the original owner of the
Right.
property. Yes, your lordship.
Now, Bala Singham purchased from Muniam,
Muniammar.
which is evident from Exhibit A1.
Right, your lordship.
Sale deed of 528.
Yes, your
No
lordship.
problem.
No.
Bala Singham availed housing loan also by executing a mortgage
Yes, your lordship.
in 1982.
Yes, your lordship.
And the parties are Christians.
Yes, your lordship.
They are governed by the Indian succession.
Yes, succession.
Bala Singham was survived with his wife, Mani Kavali, and Mrs. Mary Subaratna. The problem is,
Yes, your lordship.
what is there to indicate that Mrs.
The twen-
Hilda is the widow of Bala Singham?
Lordship, there is a Right to Information Act we have applied to your lordship. The Right to Information Act at page number 115, your lordship, it is mentioned that she is and even otherwise, your lordship, even otherwise, your lordship, it is kindly see paragraph number 26 of the impugn order. It says that admittedly there is no evidence on record as to when the defendant came into possession. I have a categorical finding of the trial court, your lordship. Even it is the plaintiff's case that came into the possession in 1987, your lordship. I'm in continuous possession from,
If you look at
2023.
para 27,
yes, your lordship.
but for the fact that you are not governed by Hindu Succession Act,
No, no, sir. Lordship, I'm not entitled.
Children will have.
Lordship, I'm not entitled. Even otherwise, Your Lordship, I'm eligible under the adverse
Nothing.
possession, Your Lordship.
Yes, miss.
No,
Next
adverse
matter.
possession, Lordship, adverse, kindly consider this adverse possession, Lordship. It is admittedly, I am there in possession since last 23 years, so Lordship, it was not disputed by the plaintiff. And in fact, the plaintiff's vendor has not disputed that she was never claimed this possession, and she never claimed this at any stage of arbitration.
That's it. Dismiss. Next matter.
Obliged.
Item 25, my lords, I am aggrieved by the finding of the High Court at page 3, paragraph 4, that it is the admitted case of the plaintiff that B scheduled property is the absolute property, my lords. I straight away invite my lords to page 46, plaint, my lords. Page 46, my lords, Roman 5. It is the specific averment that the ancestral joint family properties of Natesa Padayachi were divided.
Who are you?
I am the daughter of the alienor, my lord, daughter and son.
Your case is that this is an ancestral property.
Yes, my lords.
Now come to para 7, ma'am.
Yes,
Come to para 7.
yes, my lords.
The first question of law may
Yes,
be
ma'am.
applicable to a case where the father alienates the property of a minor without the permission of court.
Yes, ma'am.
In the present case, the suit property is not
The joint
joint
family
family.
property.
to which plaintiff should claim any right.
As-
Show us that this is a joint family property.
My lord, straight away then defendant's admission, my lords, at page. The first defendant's admission, my lords,
Now, let us complete the reading of the entire para 7.
Eight also.
83.
Shobha, eight
Yes,
and 8 both.
8 also, assuming it is joint family.
Yes, my lords. Assuming for a moment that the suit property was sold for any immoral purpose.
Just a-
That is also established.
Yes. Now,
I will
now-
take my lords through 3 pages only. If my lords are not satisfied, I will not press any further. First page 21, my lords, Annexure P1, which is the partition deed under which money gets this property.
Who contested the suit?
The purchaser, my lords, alienee under the sale deed by the father,
This sale deed is of which year?
79,
At that time, your client was aged
2 years.
2 years.
And P2 was in the womb. He was a child in the womb. my
Right.
lords.
Now, therefore, you are the plaintiff.
Yes, my lords.
It is your case that this is a joint family property,
Yes, my lords.
right?
Yes.
The burden is on you to establish.
Yes, it is admitted by defendant 1, my lords. My lords may kindly come
Wait
to
a minute.
page 83.
Wait, page?
83. Deposition of DW1, my lords. He admits.
Who is DW1?
He is the alienee. He is the sole defendant in the suit. Cross-examination at page
Yes.
83, top of the page, my lords.
Any PDF?
PDF page.
Annexed.
This is the deposition, my lord. This is Annexure P5,
Internal page?
internal page 65, my lords.
Which part you want to read?
This is cross-examination of the defendant on 25607. In the SLP paper book, my lords, top of the page, my lords. I do not know that the second plaintiff was pregnant while I was purchasing the same. It is correct if it is stated that the suit property was the ancestral property of money. He admits categorically, my lords.
So will this admission be sufficient to allow?
My lord, Section 58 Evidence Act, my lord, admitted fact need not be proved, my
You
lord.
show us something, that this was not a self-acquired property of money. Money acquired, money derived it from his father.
Then again, page 21, my lords, partition deed. Under which money gets this property, my lord, Annexure P1.
Okay, let's for the time being proceed on the footing. It was a joint Hindu family property.
Yes, my lords.
Co-parsonary property.
Yes, my lords.
In partition, money got his share.
Yes, my lord.
Well,
Yes,
if money got his share in the partition between other co-partners,
Yes.
whatever share he derived becomes his absolute.
My lords, but by then, P2 was a child in the womb. He's a son. He becomes a
Let-
co-partner. He has a right by survivorship. Even a child in the womb has right by survivorship, my lords.
Envantara Samir.
Yes, my lord.
So, the thing is, appellate court says it was for legalness.
You know, there is burden is not cast properly, my lords. My lords are quite well aware.
You notice.
Grateful, my lords. Very grateful. There is 133 days delay, my lords. I'm so sorry. I should. Thank you. Grateful.
Yes. We are still hopeful.
My lords, something cannot be there.
Talk
Come
to
to some point, it's the merging point which is eluding all of us.
We have been hearing this matter past almost 2 days. We have devoted much time in this matter as we are hopeful that we can save the marriage between the couple, between the parties, and more importantly, thereby we can secure the career of their minor daughter, Ahana. Ahana is 5 years of age as on date. Yesterday, in the course of the hearing of this matter, we thought fit to speak to the parties individually in our chamber. We first had a talk with the husband and thereafter with the wife. What we have been able to gather after hearing both is that the husband has love, affection, and respect for his wife. And in the same manner, the wife also wants to save the marriage and reunite with her husband. However, few hiccups, or we may put it, the usual wear and tear of the marital life took a heavy toll on the parties. This led to a lot of bitter feelings between them. Ultimately, the wife decided to leave her matrimonial home, and she is now residing at her parental home in Vizag,
Vijayanagar.
in Vijayanagar, state of Andhra Pradesh. The husband is a practicing advocate. Earlier, he used to reside in Vizag. However, for his better professional prospects, he decided to shift to Hyderabad. Now he is practicing in Hyderabad. Ahana at present is with her father. Ahana seems to be a very bright child. She appears to be very talented, participating in a lot of extracurricular activities. And what we have been able to understand is that if she is able to perform well in some event, she may get into the Guinness Book of World Records. At any cost, we want the parties to reunite and save the marriage, at least for Ahana. Next. The parties have been able to reach to a consensus that the wife will come down to, to some consensus. The husband has agreed to provide reasonably good accommodation in Hyderabad for his wife to stay. Well, the husband will start looking for some rental premises. And once he is able to identify 3 or 4 or 5, he would immediately inform his wife to come down to Hyderabad and have a look at those premises. Ultimately, it is for the wife to take the final call as regards the rented premises. Wherever she deems fit and proper, she may go for that premises. The rent will be paid by the husband. Above all, what is important for us to notice that the husband has assured us that he will take due and proper care of his wife in all respects. They may not be able to start living together all of a sudden because of the friction that has taken place. But we are sure with passage of time, the differences between the husband and wife may be buried, and one fine day they may all start residing together as a happy family. Right? In such circumstances referred to above, the husband shall now proceed to search for a good rental premises. Once the premises are identified, the wife will travel down to Hyderabad, have a look at those places, and then come and settle in the house so that she can spend time with her daughter Ahana. तो ये लास्ट लाइन निकाल दो बस रहने दो the husband has also agreed that he would bear all the expenses for the maintenance and better living of his wife. Okay? Post this matter, Ahana may spend time with both father and her mother, with some distinct understanding between the parents.
Maybe brother spent a lot of time, 45
My
minutes.
lords, this is a classic case where we learned, my lords, as counsels, the effort and the time
No.
given by a constitutional court, my lords. I mean, the human side of this court, at least from my side, for the first time, I'm seeing something of this nature happening.
There is human side in the constitution also. We owe it.
Exactly.
We owe it.
Daughter will join the.
We are grateful to the learned amicus for all the efforts he has put in so far. We express our gratitude towards the learned amicus.
Obliged.
We also request the learned counsel appearing for the parties to make all possible efforts till the last to ensure that the marriage is saved and the parties start residing together as one happy family with their daughter Ahana. Posted after 5 weeks? 5 weeks? 6 weeks?
Post Diwali.
8 weeks. Huh? The further progress in the matter shall be reported on the next date of hearing. Since we have devoted a lot of time in this litigation, we treat this as a part.
Very.
Huh?
In the meanwhile, that guardian ward's fiction is pending is, that may be.
That
Not
will
received.
be,
In the meantime, all proceedings between the parties shall remain stayed.
Very.
Right?
obliged. Lord.
Fine.
Nothing further. Sure.
Obliged.
He herself felt that this is the better way to put it.
Yes, my lord.
He felt that husband's help will be needed to look after. So
Definitely.
let them arrange how to look after. That is, you are asking for exclusive custody.
The daughter will join once the mother
They
will.
have decided to have, mother also felt the conversation that she will need the father's help to look after the daughter.
Right.
So we are not saying anything about exclusive now. They will arrive at some arrangement.
They will definitely, after this, they should definitely maturity. Some understanding would be there, my lords. That's shown.
Obliged.
Deeply obliged, my lords, deeply obliged.
Great.
Next.
That's the cell deed of 2004, my lords, challenged in 2022 after 18 years. That's also on the, and the challenge is on the illusory cause of action, my lords. High Court dismisses my revision, 711 and revision on the ground that the limitation cannot start from the date of registration. That's the finding of the High Court, para 17, page 25. As your lordships has held it that registration of a cell deed would be a constructive notice under section 3. Uma Devi, your lordship, Bukun Trust, your lordships have held is a constructive notice.
Tatvam Patel is an expert in this subject.
My lordship.
He knows that this has been explained by the Patel. Have you gone through Justice Qureshi's judgment?
Please, your lordship.
There he said that don't go only by the constructive notice. Sometimes you have to take a practical view of the matter. Party may not be aware. When you apply constructive notice, that is by a deeming fiction of law. But there may be cases where party.
Here, my lords, may I submit, my lords? Here he says, my lords.
Show us something.
Yes,
Forget about the constructive part.
on suit, my lords, may have.
Show us something.
Yes.
That he was aware of it.
My lords, may have page, his everments, page 10 and suit, my lords, may I just take your lordship to suit, my lords, his everments. It's first, my lords, may have page 60.
Okay, have you gone through the recent pronouncement of this court authored by Justice Narasimha on constructive notice?
That's just the Daliben's judgment, my lords. That thereafter Uma Devi has been pronounced by Justice Dhulia. That's Daliben.
What have they said about this constructive notice?
Yes, my lord. This is Uma Devi.
If we have to strictly go by the date of registration, then the suit is barred.
Lordship, please. Lordship, please. So, your lordship says,
You are questioning the sale deed on what ground?
no, they are questioning. I am not questioning. They are questioning. I am the defendant.
Sorry, you are the.
They said I had my right, which my predecessor's name has not been entered into the records in 1988. That is what their claim is. And that continued till registration of sale deed. Their predecessor's name was not entered into revenue records. That is their claim since 88. And his predecessor never raised an objection because.
You tell us.
Yes, my lords.
Who executed the sale deed?
My lords, his family members, the plaintiff's family members, his uncle is.
Who was the original owner of the property?
The grandfather, his grandfather, the plaintiff's grandfather.
It's an ancestral property.
It's an ancestral property.
No partition took place.
But that's the, in 88, prior to, because then in 88, when there was a mutation happened after the ancestral death, his name was purposefully left out. We are not aware as to how it has been left out because we came into picture in 2004 when we purchased. His name was purposefully left out. Therefore,
why does High Court say that no cause of action is made?
Therefore, may I request my lords to see that para 10 of the cause of action paragraph, if in the suit, my lords, page 67.
Annexure?
That would be, I'm sorry, my lords, just a minute. Annexure would be P2. P2 is the suit, my lords.
Beg your pardon?
Annexure P2 is the suit. And then in cause of action has been mentioned in para 67, page 67, para 10.
Annexure.
P2, my lords. Annexure P2 is the suit. Internal page 67, it's a cause of action. May I read the cause of action portion first, my lords, and then we'll take to his averments as to how his name has been left out.
Paragraph?
Paragraph 10. The reasons for filing of the suits arise. Am I with my lords?
Yes.
arise since the grandmother of the plaintiff Jasodaben Bhagwan Das died in 15/4/1987 without executing will codicils. Since the father of the plaintiff Kanubai Umayabai Sankar died in 88. Since the defendant assembled and in their collusion created false documentary evidence like Pedinama, the reply of third party application, and on that basis they have got entered mutated revenue record and executed sale deed in 2004. So his name was left out in 88 itself.
What was the age of this?
He became major in 85. The plaintiffs,
What is his name?
Sanjay and Jatin, the plaintiffs, Maharaj.
And who is this Kanubai?
Kanubai is his father.
So after Kanubai passed away,
Yes.
in what manner the revenue records came to be corrected?
Nothing has happened.
Kanubai's name was never reflected.
Was never reflected.
Why?
Because
Kanubai doesn't have a share in this process.
it appears that partition might have taken place prior thereto. We are not aware of it. We came into picture in 2004, but in revenue record since 88,
You are
it continued.
appearing for
Purchaser.
purchase.
Purchaser. I purchased land in 2004. Sale deed registered.
And the suit came to be instituted in
2022. 2004, it was registered. Possession handed over. I am in possession.
In the meantime, the further proceedings of, is it a regular
Civil suit, Malos.
regular civil
Page
suit number?
56. 436 of 2022, pending before Principal Senior Civil Judge, Ahmedabad Rural.
Shall remain state.
I'm sorry.
Give them dusty.
I'm sorry.
May it please, my lords. My lords, there are two orders in the challenge over here, my lords. First is the amendment petition that we had filed regarding amendment of pleadings that was rejected because saying that there was a delay and delay was not explained. But we had brought forth the pleading that there was a fraud committed on the end and the vendor had no title or possession or right to sell this property. Second, my lords, we had filed a second appeal, which the Honorable High Court has stated that because a suit and a counterclaim was filed, two appeals were supposed to be filed and not one appeal. Our argument was because it is a consolidated decree, so therefore, my lords, one appeal was maintainable. My lords, there are 5 High Court judgments. 3 are saying that to a single appeal can be filed. While,
Type of amendment you wanted?
my lords, what had happened was the property, the vendor, he had no title on the property that he sold.
The suit is at what stage?
My lords, the suit has been disposed of.
Correct.
The appeal has been disposed of.
Right.
We went in the second appeal now.
Ah.
And in the second appeal, when we came to know about this fact, that was the 1954 judgment that I've annexed with the petition. My lords, I filed an amendment petition. That amendment was rejected because
Amendment of what?
of the my written statement before the trial court, my lords. We stated that because the vendor had no title, so therefore we stated that as he had no title.
Second appeal stage he files now.
We'll keep it on Monday. Some of you have missed this one.
Obliged, ma'am.
But the suit came to be dismissed, na?
My lords, the suit came to be allowed, the counterclaim came to be dismissed.
Ah.
there we have to be filed a single appeal against both the orders.
Right.
The appellate court confirmed it. Now what happened was when we went to the High Court in second appeal, the High Court stated that because you have not filed an appeal against a counterclaim, you have to file two appeals.
Correct.
Therefore, the res judicata comes into play.
Correct.
But my lords, our argument was that because it was a consolidated decree and a consolidated judgment, therefore one appeal is maintainable. My lords, there are differing judgments before the High Court.
But this has nothing to do with your plea to amend the written statement.
No, my lords, but there are two orders that have come into challenge. I have challenged both the orders because both the orders were passed on the same day. So therefore, I have to challenge both the orders, my lords. Yes, my lords, but it was as it was pronounced separately, so I had to challenge both the orders together, my lords.
But you come to this page 6. Just read this finding.
My lords, point 7.
Page 6, internal page 6, para 7. Much water has.
Much water is flown down the bridge.
It should not be flown, it should be float.
What's that is?
Water can't flow.
No, that's high.
Much water has
Flown down the bridge ever since. Since the estate was
estate was recorded in the name of the state government. The Act's intermediary filed a suit being title suit number
58 of 93.
Same was decreed by declaring the title of co. This decree never came to be challenged till date, and as such has become final. As argued by Mr. So-and-so, has not placed anything on record to show why the proposed amendment was not sought to be introduced earlier and is being attempted to be done at this belated stage. Any good reason for
My
us
lords,
to-
our argument was that we did not discover this judgment of 1954, where this property was owned by the Raja of Patia. He had purchased it through an auction proceedings, and therefore he had the right title and interest over
And on the
the.
strength of this, how will you defeat the claim of the?
My lords, we were saying that because he had no title, therefore the entire sale has to be cancelled. Whether it's for us or whether it's for them, the entire sale has to be cancelled
You
because
don't get anything.
No.
Plaintiff doesn't get
No, my
anything.
lords.
Then land goes to whom?
to the estate of Raja of Patia, my lords.
Next Friday.
My lords, next Monday or Friday?
Friday.
Obliged,
Friday.
my lords.
Yeah.
My lords, in item number 28, I beg to appear on behalf of respondent number 2, my lords.
Uh,
My lords, this is a MA suo motu which has been taken up by the court, my lords, for the depositing the amount.
So who appears for the petitioner today?
I'm for the petitioner, my lord. We
Have
had
you
already
deposited
deposited.
this amount?
Yes,
5
it's
lakhs?
long back, my lord. It is the respondent number 2 has not been providing the account details. That is why the amount could not be transferred to the account of the respondent number 2.
And who appears for respondent number 2?
My lords, I appear on behalf of respondent number 2, my lords. I appear virtually. I apologize that I could.
So why are you not providing your account details?
My lords, we have been trying to establish contact with the client, but unfortunately, the number which we had is not available, and my lords, person is a very old man, so I am unfortunately I'm not able to establish any contact. In fact, I had informed the local council as
So
well.
the Supreme Court Special Lok Adalat. The following order was recorded, dated 29th of July 2024. Spoken. Sorry, this matter has come up before us today with the office report stating that the amount of rupees 5 lakh deposited by the petition in accordance with the settlement terms is now to be dispersed and released in favor of the respondent number 2, Jitendra Bera. But Shri Bera till this date has not furnished his account details or has not come forward to claim this amount of rupees fine. Mr. Shivam Kumar, learned counsel appearing for Mr. Bera, would submit that he has no instructions from his client. We grant one last opportunity for the respondent number 2 to Jitendra Bera to furnish the necessary information as regards his bank account. Post it after 2 weeks.
Grateful, my lord.
May it please the Lordship, my lord. There are two appeals, my lord. There's a delay of 177 days, my lord. That is enumerated in page 185 of, my lord, one of the SLPs, my lord.
How do you propose to invoke arbitration?
My lord, on the
Signatory to the main agreement itself?
Yes, I admit. Now what I say is, my lord, that, my lord, the agreement was entered upon between the firm and the BPCL, my lord. There's no dispute with regard to, my lord, me being a partner, which is another agreement which I seek specific performance in a separate suit, my lord. I'm not seeking any relief with regard to that, my lord, against BPCL, my lord. Nobody is disputing. I'm sorry, my lord.
Page 4.
Yes, my lord. Of the impugned order, my lord. Yes.
Read the third paragraph. This court has to decide. Read it.
Should we seeing, my lord, section 11, appeal from section 11, my lord, or the appeal from section 37, my lord? There are two appeals, my lord. One is from section 11 application, my lord. This other one from the division bench, my lord.
No, we are reading this order of the High Court. Dated 27th.
That's a single bench judgment. Yes.
So just come to
Yes, my lord.
Page 4.
Yes, my lord.
Internal page 4.
Yes, my lord.
The third paragraph. This is what we have understood. This court has to decide whether the petitioners, non-signatory to the memorandum of agreement,
Yes, my lord.
dispensing pump and selling license dated, can invoke the arbitration clause and approach this court for appointment of arbitrator in terms of clause 19 of the said agreement.
Yes, my lord.
Then it says further, it appears that there was an agreement between the petitioners and partners of Ambika Service Station. When the petitioner came to know that another undated agreement had been signed by the partners with a third party, a suit was filed. This is all okay. Internal disputes.
Yes, my lord.
But then, how do you say that I have a dispute with BPCL and therefore appoint an arbitrator?
No, my lord. My right with regard to, there are two things, my lord, needs to be taken into account, my lord. I was undisputedly in control of the business from 2015 till 2022, my lord. For 7 years, my lord. There are documents, my lord, when the application under section 9 was allowed, my lord, and yes, my lord. The agreement between the partners or the agreement between BPCL? BPCL, yes, my lord.
Today you want to drag BPCL into arbitration.
Yes.
Take us to that.
Yes, my lord. Lord, she will kindly take, my lord, the page 27, my lord.
Sure.
P1, my lord.
Now just say.
I'm sorry, my lord. P2, sorry. I'm sorry, page 33, my lord. I'm sorry. P2, page 33, my lord. That's the licensing agreement.
It is between
Bharat Petroleum, yes.
and
In the and, my lord, in case of a firm, I'm on 2, my lord, and 1 in case of an individual, I'm not on that, my lord. I'm on the other one, my lord. In case of a firm, the present members of the said firm and any other member for the time being of the said firm there and each of their heirs, executors or administrators. I'm on this aspect, my lord. There, my lord, may I hand over one copy, my lord? There's the original one, my lord. While typing it out, my lord, the handwritten portions were, my lord, omitted, my lord.
Who signed this agreement?
Agreement was signed by the erstwhile the respondents in the suit, my lord, who were the original partners, my lord. We were inducted in 2015, my lord. We were inducted in 2015, my lord.
Who inducted you?
My lord, the original partners, not BPCL.
BPCL recognized you at any point of time.
That was the original dispute. That was no.
That's the end of the matter.
No.
That's the end of the matter. Then how do you say that I want to go for arbitration?
Well,
Dismiss. Next matter. Next matter. What is this?
Lordship, this is a 302 criminal appeal. Trial court has convicted for life to 3 accused persons. High Court reversed it and acquitted them.
On what ground?
Lordship, the High Court says that the statement of the injured, there are 4 injured eyewitnesses. Grateful.
May it please your Lordship, I appear for the petitioner state. The Honorable High Court against the appeal against conviction under 302 converts it to 304 part 2. However, the findings are contradictory. If your Lordship sees page 38.
What are the injuries?
Injuries are at page 35.
Annexure?
It's in the impugned order itself, your Lordship. Page 32.
What is the weapon used?
Iron rod.
Which part of the body?
Head.
How many blows?
1 blow.
The genesis of the occurrence? How did the incident occur?
So your Lordships, these, there were 4 family members.
You said page number?
Page number 32 are the injuries that are reproduced by the Honorable High Court.
Internal page?
Yes, your Lordship. SLP paper book, page 32.
Okay, come to para 34.
Yes, your Lordship.
Dr. Sachin
Yes, your Lordship.
conducted the postmortem.
Yes, your Lordship.
Obliquely placed linear sutured wound, so and so, so and so, so and so.
May I only submit, your Lordships, there is no dispute about the incident as such. The Honorable High Court converts it, saying that, I'm sorry.
Absurd, absurd, absolutely absurd, absurd. Notice issue kijiye. We'll have to remand it. This is not 304. This is not 304. Perhaps this is not even 304 part 1. This doesn't fall within any one of the exceptions also.
Absolutely.
Bombay High Court? Strange. Dusty de dijiye.
Highly obliged. 31.1 is also connected.
Same.
Grateful.
Lordships put to me last time, it's a reduction of interest. And therefore, my lord, I want to answer 2 points.
Have we passed some order in the past?
No, my lord, it's a fresh matter. Kindly see page 7. My lord, my concern is this.
I have something to say, my lord. So day before yesterday, matter got listed. My lords directed them to file additional documents because this itself is bereft of documents. Now they have midnight, my lord. They have filed certain documents. We don't have a copy.
Okay, Friday week.
Yes.
My lord, my apologies. It's a mistake on our part. It's a mistake on our part, my lord. My apologies.
Accommodating him.
That all right, my lord. My apologies to him and to the bench.
Maybe served on.
We'll do. You should have filed it.
Let's, I would like to also see these dates I made. It is blowing to smithereens 12A and my Lord Justice Padiwala's judgment a few days ago. It's smithereens. And if I'm exaggerating, your Lordship should not accept my submission. Just kindly see what is happening here.
That premeditation, sorry.
12A, Balas, that 12A. I mean, your Lordship may repeal 12A if this kind of conduct. Kindly hand over the other one to my Lord Justice Padiwala. Just give me 2 minutes on this. No, just 2 minutes. I've had it made specially so it's faster, easier. Whereas I am petitioner, he is a respondent, he is fighting me on some iron ore, saying that this is his, I have sold it to him, etc. That's the merit. That's not relevant. Just come to item, 3. Does my lord have it, Malas? I challenge a suspension order passed against me by the collector who stays it. I filed in number 4 a police protection writ. Lordship got the number? Now the police protection is because miscreants, which means him, are against me. Kindly follow that for a bit. It will be a little interesting to Lordship how you can avoid 12A. It's very extraordinary case for us. Then he files an IA number in item number 5, intervening in my police protection writ in item 5, which is 2024, March. That IA does not seek any stay, no urgency. I hope I'm clear. That is dismissed in number 6, his IA. This is in March 24. On intervention IA, without seeking a stay, because today he says, I want extreme urgency, waive 12A and give me stay. He doesn't seek any stay then. His stay today, his stay is that I should not sell, touch or deal with the iron ore.
You should.
I should not. This he could have sought from number 5. Just see 5.
What are your business relations?
My business relations is that I never agreed to sell to him. He has filed a specific performance suit. It's just coming in 2 minutes. Just bear with me. A lordship will be a little shocked about 12A. Now, my point in number 5 is that this the Lord author a judgment, but you will see how the judgment is blown to smithereens.
Dr. Singhvi, would it not depend on the facts of each?
That's the facts. These facts are the most perverse facts ever imaginable.
There is an urgency.
Yeah.
Court may assign reason.
Absolutely. No. So I start with number 5, where he could have sought urgency and stay. He did not.
One thing. Tell us.
Yes.
Exactly what is the dispute?
The dispute is a specific performance suit he files after 16 months of starting all this, in which he says that there is one exemption and one order 39. 2 things. So exemption is from 12A, his suit. He's the plaintiff.
He is seeking specific performance
Of an alleged agreement.
What is the nature of
by which I have to sell to him the ore.
You are procuring ore by mining? You are undertaking mining operations?
Yes.
So whatever you excavate, you have to sell that ore
to him.
That's your understanding.
That's the original suit for specific performance, which is filed 16 months after number 5.
Fine.
In that he says, I want order 39 interim injunction and waiver of 12A.
Right. Your argument is
yes,
12A would apply if parties must go for mediation and resolve it.
Yes.
That's your argument.
And the argument is that 12A in the commercial court context was introduced.
Now, if he is able to secure that particular relief which he is seeking, you may be able to excavate, but you cannot sell it to some other party. That is your problem.
He has got a stay after 2 years, pretending urgency about non-sale.
We are just trying to understand the implication.
So the stay is...
So either you have to stop the operations,
or
you
not
don't
sell.
have to excavate,
or not sell.
Or if you excavate, you have to keep that entire thing over there only.
Correct.
That's the thing.
I'm grateful.
But y'all can't sit and trash it up.
Not for the reason, just whereas your lordship will just even for more as an example of litigation, this is very interesting, not for this case. 5 minutes will be very interesting for your lordships. Lordship will decide whatever, because your lordship will not have seen these facts. Just bear with me for just 5 minutes by the clock. I've got this list of dates made for that reason. So item 5, he intervenes in my police protection writ, does not seek stay, seeks no urgency. Right, Bruce? 5 is March 24. 6 is his IA for intervention without a stay is dismissed. Then come to Malas, item 9. I'm not reading all of it, Malas. 9. He then attacks me asking the collector to recall the order. This is the second time he could have sought mediation or any interim relief. This is now in July 24. In item 10, he files another IA again for intervention without stay in July 24 in my writ. Copy to him now. No, it's a review petition. His order is passed in review.
He wants to defend this on the premise that the suit still cannot proceed.
And that too.
Client of Mr. Subramaniam has not been able to get any order, no?
He got a stay. After a review petition, in a review petition against an order where he himself lost,
Okay.
which attained finality.
This order,
Yes.
you have not challenged further?
No, that is a merits order. I will challenge it on merits. I've still got 90 days.
Today,
I am only on 12A.
so your argument would be that because of 12A, his injunction application should not have been entertained.
Was dismissed. The trial court returned the plaint. Against that, after 1.5 years, he goes in a review. The review court doesn't have an application for stay, doesn't have an application for anything. In that review, IA, he files and gets an order contrary to an earlier order by the same court which had dismissed him, which he had not challenged. Give me one, these dates have to be seen. Whereas the Lordship will just spend less than 5 minutes, but Lordship will allow me to go on the.
My brother's question is absolutely- 31.7 is the return of claim.
Yes, now so let's.
Spending in,
No,
pending in
can I just kindly?
You got your point, Mr.
No, come to 15. Well, just one page will be left. Come to 15. Just say Padiwala may take number 15.
It is a suit.
That is his suit in which he has today now got a stay without 12A.
That is by the 711 order according to.
Yes, but Malas, this suit is filed after 16 months of the agreement, and it is filed, Malas, after all the earlier writ petitions where he's intervened over 1 year. Now come to 16. Returned suit. Returned the plaint. My lord has got, Justice Padiwala has got. Malas, one more thing. Your Lordship in 12A has said it is not a formality. Everybody will pretend urgency. It doesn't mean that if I file 39, order 39, 12A gets waived. Everybody at 39. Then, Malas, this order, they are important dates, fellows. 17, he challenges the order by filing an FA. This is very, very important. My lord has got 17. My learned friend's suit is returned in 16. In 17, he files a first appeal. On 18, the order is reserved. On 20, the High Court rejects his interim relief. Would my lords double tick 20, Malas? Would my lords double tick 20? 14th of August, his interim relief is rejected. All this while he has not complied with 12A.
Points for you to vacate that 711 order or not, but then.
No, all this while he's not at 12A. Now just what he sees. In Malas, he challenges an item 23 by filing a review petition in 23. In this review, he has filed against an IA dismissing intervention. This is a little serious. In 21, he files yet another IA in my writ. Justice Padiwala may have 21 Malas.
Yes, Dr. Singh.
These facts are very important.
Come to paragraph 42 of the impugned order of the High Court.
Yes.
Page 50.
Yes, Malas.
Just, let's read 41 also. We may note that by order dated so and so in review petition,
This court directed that status quo shall be maintained by order dated 9/1. So therefore, Malas,
by order dated while
permitted to withdraw the review, liberty was granted to pursue its remedy in the present appeal, and the interim protection is extended. But that is why your Lordship may leave this for a minute. Just trust me for 2 minutes. Just see the list of dates. Three dates. Then I'll not press it. Because Malas, this is not clear. Just bear with me, Malas. Your Lordship has got 16. My Lordship Padiwala has got 16. Your plaint is returned for lack of 12A. I hope I'm clear. Then, Malas, he challenges it and orders for interim are reserved at 18. The very same interim he's got now is reserved at 18. My Lord has got that? The judge.
But after it is returned, there is a question of reserve.
No, in appeal court. The trial court returns it. He goes to appeal. In the appeal, is reserved at 18. He is denied and dismissed in 20. Mark that very important 14th of August. Dismissed. He does not challenge this.
In 24.
No, 20. That's the catch.
Give me the serial number.
Oh, no. Oh, I'm very sorry. My apology. I made it for convenience. That's all. I should have said so. I thought your Lordship.
Yeah.
No wonder your Lordship might be disoriented if I'm saying. Well, it's 20 is in 14th August 24. I hope I'm clear, Malas. You have dismissed the interim application in appeal. You don't challenge it. Then, Malas, he files this is extraordinary, Malas. In 21, he files an IA 10875. in my separate writ asking for protection. I hope I'm clear. This is my writ. This IA has no stay. It's only for intervention. That order of item 20 and 21. In 21, his IA is dismissed for intervention. He challenges that in item 23. For intervention, he challenges by filing a review. So it's a review of a non-intervention order. I hope I'm clear, Malas. In that order, High Court passes first and status quo. How? I'm asking myself in 24. No interim relief is sought by him. No parade. And it is passed contrary to 14th of August, where he has lost the main appeal. Now, one minute, Malas. He withdraws the review. Para 25. Well, Alice in Wonderland, Curiosity is not the right word here. He withdraws despite withdrawing a review of a non-intervention, he gets an extension of status quo. I hope I'm clear.
Yes.
Then in 26, the status quo is second time extended.
Converted to FA status quo.
In what? In a review against a non-intervention. And then comes the impugned order on the next page. Now, Malas, bear with me, the errors. But this is, Malas, because your Lordship has said, just turn to your Lordship judgment for a minute. Barring 2 paragraphs, Malas, all of the judgment has to be seen. Kindly turn to your Lordship judgment. Very recent judgment. I'm not citing it because Justice Padiwala is the author. It considers all the law at one place. It's called Dhanbad. Please give it.
May I?
No, just 2 minutes, Malas. Today I'm in appeal on a 12A. My Lord has said what happens, Malas, when I file a suit. If I file 39-1, the law is not that every 39-1 is urgent. So why have 12A? Why have 12A, Malas? Your Lordship has, Malas, punctured that theory in this judgment, which is blown to smithereens. Please see that now. Just bear with me for this. Kindly hand it over 2 copies. Just turn to para 62. He's try again. He gets some relief in a review. Does my Lord have 62? May I? Please turn to my Lord's conclusions at 62. Everything is summarized at one place. May I read with my Lord's permission?
Yes.
Conclusion.
Read it.
The decision of this court in Patil is cited by the impugned order, lays down the correct position as regards 12A, holding it mandatory. 2. Para 104 of Patil, the declaration of mandatory nature relates back to the date of the amending act. 3. Para so-and-so of Patil, any suit which is instituted under 2015 without complying is liable to be rejected under Order 7. Not necessary here, but the Lordship has gone that far. However, this declaration applies prospectively. We are a prospective suit for us. A suit which contemplates urgent relief may be filed without first resorting. No problem. Not in these facts. Then come to E. Unlike 82, leave of the court is not required. Forget that. So D is Malas general principle. E can be ignored. F. The test for urgent interim relief is if on the examination of the nature and subject matter of the suit and the cause of action, the prayer for urgent interim relief by the plaintiff could be said to be contemplable when the matter is seen from the standpoint. This man is going on from March 24. He gets this in 25, 1.5 years later. He can't go to mediation. Then, Malas, courts must also be wary that urgent interim relief must not be unfounded excuse by the plaintiff to bypass. My Lord has used the word camouflage in the body of the judgment. Then even if the urgent relief ultimately comes to be denied, the suit may be proceeded with without compliance if the urgent is satisfied, notwithstanding the actual outcome of the merits. Now, Malas, the Lordship is given I. This is very important. I. Suits without complying with 12A prior to August cannot be rejected under 7. We are not that, Malas. Come to J. My Lord has got that? We are J. In suits without complying with 12A prior to 28, which are kept pending adjudication before the trial court, the court shall keep the suit in abeyance and refer the parties to time-bound mediation in accordance with section 12A if an objection is raised by the defendant by filing an application. Thus the answer, now read 63 also, Malas. If the suit is instituted on or after the date of Patil without complying with 12A, it must meet with rejection either suo motu or by an application, even suo motu. Next, B. If the suit is instituted prior to 20 without complying, we are not concerned with that particular one. Having answered, we find it difficult to accept the contention. This is para 64 on the merits of that case. Trial court as well as the High Court committed an error in refusing to reject the under 711. On the contrary, the approach adopted by High Court in the impugned order in keeping the suit in abeyance and referring the parties strikes a perfect balance between the mandatory nature as well as. Now, Malas, this list of dates starts in March 24. You have no time to do mediation and you get an interim order after, Malas, I'm sorry to repeat, I'll end in 2 minutes, Malas. After your lordships, why do you take away my paper? After, Malas, your lordship gets a refusal of interim relief in item 20. Just turn to 20. 20 is not challenged by you. Item 20. Advantage of his fruits of 12A violation. Just see 131. No, 1 minute, Bombers. 131. What is the application your lordship is facing? This is the way you exempt. 131. Just see, this is exemption he seeks. If this is so, I repeat, you might as well repeal 12A. 131. Annexure. Annexure? So paper book page 131. What is the annexure number?
Dr. CG, you first placed that 711 order here in a review against a rejection of intervention. That is supposed you placed that order.
Yes, yes.
So that issue of
Yes. After 1 minute, 131 will my lord see. Just for a minute, if lordship doesn't mind. Kindly see 131 for just 1 minute in the main volume. The main volume, no? I mean, just see Malas, the main volume for 1. This is not the way you can get an exemption, Malas.
Yes.
131.
Yes.
Delightfully vague, one page, 1.5 pages. Filed the commercial suit. Craves leave. Praise the plaint will be kindly read. Bent on dishonoring. Continually violating the agreement, clandestinely transporting. This is happening for 1.5 years. Clandestine transport. Then, Manas, in case the defendant succeeds in achieving his illegal designs, forcibly ousting and unjustly enriching the lawful belongs to plaintiff, plaintiff will suffer an irreparable loss which cannot be compensated. Due to the urgent nature, please, Manas, give up 12A.
Now, where is the order on this? First order on this?
Yes, the first order on this, Manas, in the suit is 14.8. Come to page 34. I'm sorry, 223. 223. Apologies. 223. This is the first time. So, Manas, the first order is 166 when the plaint is returned.
P19.
Yes. So, Manas, just for correctness, the first order is page 166 when the trial court rightly returns the plaint. I hope I'm clear.
After this application was filed.
Yes, he returns it. The trial court gets it right according to me. He returns it. Now he files an appeal. In appeal, the order he gets is 223. Show me 223.
You notice on payment of process fee.
No stay. Issue notice. There are 3 issue notices on 224. Turn the page. List after 4 weeks. No interim stay given.
Understood. Then what happens?
Then, Malas, he files an IA in item 21. Keep my list of dates open. It will be easier. In my writ for protection from police, this IA 108, page 34 of the second volume, page 34, is for only intervention without stay. My learned friend, Mr. Gopal Subramanian's client, seeks intervention in my writ for police protection, no stay sought. On this, Malas, then he files a review petition at page 230. Turn to 230.
Annexure.
This is page 2, annexure number. Why don't you give annexure numbers here?
21. Annexure
P21. P21. 230. Now in this, Malas,
this review is against which order?
Against item 20.
Show us that order.
Yes, order is 223, page number.
P19.
Annexure P19. The one your lordship just now saw. Issue notice. Now against this, he files a review in an intervention application which is dismissed. I'm sorry, I didn't show the dismissal. The dismissal is page 34 of the second volume.
So after P19,
yes,
there was a final order of dismissal.
No, P19 was a notice.
Then what happened?
Then he filed, Malas, item 21 IA in my writ for protection, police protection, where the prayer at page 34 of volume 2 is of the IA is that, please allow me to intervene. This order, your lordship must read for 2 minutes. The date of this order is, please, 14th August. There are two 14th August. My lordship may get confused. Second volume, additional documents. This is a very interesting order. The second volume.
7. 4. Yes.
So this second order, 14th August, in my writ petition, page 34, my lord has got. Now just turn it 34 straight away to, well, I'll not read the rest. The whole thing is summarized. So it's a detailed order. This fight is between me and the government about police protection. The learned judge had come to 46. 46. After hearing,
Yes, yes.
well, let's just see 8, para 8. During the course of arguments, learned counsel for the appellant, assisted by counsel for the proposed interveners, opposed. After hearing learned counsel, we are of the considered view, security is a dynamic process, leave that. Now come to 47, where he deals with Mr. Subramaniam's client. Page 47, para 10. Page 47, para 10.
Yes.
Since the middle of that para, since the proposed intervener has already filed commercial suit, and after dismissal thereof, he has filed first appeal, which is pending in the High Court, after issuance of notice. Therefore, proposed intervener shall be at liberty to pursue its legal remedy in the pending appeal, which he did not challenge, the other 14th August order. He never challenged it in Supreme Court or elsewhere. In the aforesaid pending first appeal, the enforcement of agreement by means of suit for specific, wherein the commercial code at the threshold of 711 has dismissed the commercial suit on the ground of non-compliance, etc. For the reasons recorded, this writ is disposed of, and then they dispose it off. So
In this order.
now in this, against this order, that I will not intervene you, Mr. Subramaniam, he files a review. That order is passed, in review. Now just this review is important, turn to 230. 230 of the first volume. 230 of the first volume. Give me what I'm asking for. 230 of the first volume. There is no prayer for interim relief. Just turn to 230.
Annexure.
230, annexure P21. I wonder if Lordship has dealt with how many reviews of an intervention being denied. It's an extraordinary situation,
Right.
very lawyer friendly, but very illegal. 230, he files this. And then, this is the whole petition. My learned friend has checked up. There is no application for interim relief. I mean, I can't show a negative. My lord will take my word for. See the index. My lord,
Where is the final order?
now, on this, first order is page 50 of the second volume, the thinner volume of the IA volume.
Why can't you all put it in a chronology? Additional main.
This creates a problem, but the thing is that
How many times we have to keep switching over?
just keep 2 volumes only. I'm sorry. On this, the order passes 50. No, you have to put in the same SLP volume.
In the additional.
Yeah, in the second volume. Only 2 volumes. P5.
P5.
Now, in this, which is in a review of an intervention, the court is saying, file reply, etc. And last sentence, without any reason,
What did you do with
at
this?
page 57.
But what did you do with this?
I'll tell you. Page 57.
Got it.
Now, he withdraws this. My learned withdraws it. Come to that order at page 58 of volume 1. I'm very sorry to.
So with the withdrawal, the order of status quo also goes?
No, I withdraw, but extend it. Then he goes to that, the first appeal and gets the impugned order. And all this is without 12A. Well, at the moment, I'm not on merits. Will your lordships allow with this application of exemption of two lines?
Now we have understood. Yes.
Lord, may I? My lord, would your lordships kindly come to page 204, my lord?
With all due respect to
Yes.
the 2 learned judges,
Yes.
we don't approve.
My lord, may I just give a little context if your lordship does?
We smack off something very foul in this.
Try.
My lord,
Very foul.
my lord, may I?
That's the feeling. Unfortunately, we have gathered. Issue notice. Who is the AOR? Who is the AOR?
Mr. Amit Sharma, my lord.
Learned so-and-so, the advocate on record, waive service of notice for and on behalf of the Respondents? Huh?
He's one.
One respondent. So
Respondent number one. Who is respondent number two? Who are the other respondents?
Individual ex-directors are all the other respondents. Some support me, some support him.
Give them Dusty so far as
Yes,
others
we'll
are
take
concerned. Right?
Well, stay of page 15, para 43. Stay of page 15, para 43.
one submission, my lord, on that.
He cannot enjoy the benefits
May I
of his
make
law.
one submission on that?
Not be, are we not granting you the final relief?
I'll tell you why not. For 1.5 years, he did not have para 43 at page 15. So why today, Malas, he has got it by repeatedly going round and round?
Thoroughly understood. No doubt about it. Thoroughly understood.
Malas, your lordship is not bound by something which he goes and gets surreptitiously after 1.5 years without going 12A. If Malas, nothing happened for 1.5 years, why could he not have got this?
May I speak? May I make one submission? My lord, under the contract, he was supposed to supply me with 170,000 tons of iron ore.
Sir,
And I have paid the money, my lord.
sir, we are not going to touch your contract. Whatever may be the understanding between the parties, if each party is obliged to abide by
True, my
it,
lord.
they have to. But what has been highlighted is something which.
My lord, the
Unprecedented.
injunction which he is appealing against is only to preserve, my lord, my rights under the contract. Your lordships refer to
The
paragraph
bench
47.
takes that order in review and passes this.
No, no, my lord. My lord, just give me one moment. My lord,
Shocking.
my lord, I need to offer some explanation, my lord. My lord, one explanation is, my lord, what he did was, after the agreement was entered, I paid him 1 crore of rupees the very next day. In terms of the agreement, the ownership of this 170,000 metric tons of iron vested in me. In order to, my lord, defeat my rights under the contract, he filed successive writ petitions in the High Court, seeking various so-called protective orders and of police protection to enable transportation of all this iron ore elsewhere.
No original agreement, we dispute the agreement. So 24 till now, he never had it. Why should you have it now? He did not have any protection from March 24 till August for the first time he got.
Would you
And
all
no,
like-
no reason given here. No reason given here.
We have a proposal. Would you all like to go before any arbitrator and resolve it? Tell us. We'll send you all to a good arbitrator.
See, no one get
Talk,
dismissed.
finished it off.
Dismissed, get dismissed. Well, he has filed criminal actions against me.
We'll take care of
Yeah,
it.
that has
That
to be.
will take.
Then I think yes. Or a good mediator also, well, if
Sir?
you would want, Mr.
Will your client agree?
My
to
lord,
it?
I'll persuade my client.
You are
I'll persuade my client.
You're getting something you want to.
So no suit, nothing. No suit, no 12A, everything will go.
But well, criminal must go, Malal, because he is filing left, right and center and writing to the collector, stop me.
But my lord, I need this quantity to be protected.
Parties to maintain status quo.
Great.
Both sides will maintain
Great.
status quo. Both sides.
No, in all proceedings, Malal. In other matters, because all this is, he is filing so many criminal matters.
Parties are directed to maintain status quo as on date. If there are any other criminal proceedings.
There are.
with the parties, all those proceedings shall also remain stately. Are you agreeable, sir?
My lord, I am agreeable. I want this contract.
Okay.
It's only about a contract.
Okay, will you?
I have
name
paid
an
the money.
arbitrator? Come on, name one arbitrator. Sole arbitrator.
That is part of the arbitration.
We'll put an end here only, today itself.
Well, our case is that he doesn't have the original of the agreement at all. So he all will go before the arbitrator. Why do you repeat?
That's a different thing.
Yeah, that's a merit for us. My lord is right. Give a name.
But the next day, 1 crore went in a bank statement.
Give a name. Well, it's state the order, leave the name blank. Somebody will come and tell the court master. Well, just I don't want to take it without there. Otherwise, anybody, well, it's retired learned judge of the Supreme Court, sole arbitrator. Even name, any name. I forget the name. So retired now.
What are the stakes involved here? What are the stakes?
According to us, the agreement is not an original, not signed, not produced. Therefore, well, the stakes are for me. Well, my entire mining will be stopped.
So should
Stop.
There was a claim for specific performance.
Mediation is better, Malas. Mediation is better because that was the intention. And thereafter, Malas, we'll go into the suit. Then let this 2 points, Malas. Let the majesty of the law be followed in 12A. Malas, let the majesty of the law be followed in 12A. That will be done through Justice Kurian Joseph, through Mr. Panchu Gopal, anybody your lordship likes to nominate. And it will be hardly, Malas, 8 weeks, etc.
Mediation.
Mediation. And that's right. That will comply with 12A also. The matter will be over either way.
Will appoint Justice D.Y. Chandrachud, Dr. D.Y. Chandrachud.
Certainly.
Former Chief
Certainly.
Justice. Should we pass the order?
Yes. Yes. Mediation. Will also use the word mediation. Can't be given. You can't say.
And my lord, may I implore that your lordship's order status quo ante. Great.
What will you sell it with?
This petition arises from the order passed by the High Court of Madhya Pradesh.
Give us via media that you will not sell something.
Dated 11th of August
Give us via media that you will
2025.
not sell something till the date of the mediation.
In first appeal number 1050 of 2024,
May I take your lordship leave?
by which the appeal filed by the respondents hearing against the order dated 31/7/2024 passed by the Commercial Court returning the plaint filed by the respondent number 1 herein came to be returned on the ground of non-compliance of Section 12A of the Commercial Codes Act 2015. Hey, वापस पढ़ो, वापस पढ़ो. This appeal, this petition against the order dated 31/7/2024, returning the plaint on the ground of non-compliance of Section 12A of the Commercial Codes Act 2015 came to be disposed of with appropriate directions. Full point. The High Court, while disposing of the first appeal, observed as under paragraphs 42, 43, 40, and 40 respectively. Okay? The petitioners being dissatisfied with the impugned judgment and order passed by the High Court are here before us with the present petition. We heard Dr. Abhishek Banu Singhvi, the learned senior counsel, appearing for the petitioner, original respondent number 1 before the High Court, and Mr. Gopal Subramaniam, learned senior counsel, appearing for the respondent number 1 hearing, original appellant before the High Court at length. Manifold contentions were sought to be raised in the course of the hearing. By both the sides. Good. Having heard the learned counsel appearing for the parties and having gone through the materials on record, we are of the view that this long drawn litigation between the parties, which is getting murkier and murkier day by day, could be brought to an end if parties are persuaded to go for mediation before a former judge of this High Court, before a former judge of the Supreme Court. More particularly considering the nature of the disputes between the parties and the stakes involved therein. Good point. The proposal put forward by us for mediation has been very graciously accepted by Dr. Abhishek Manu Singhvi and Mr. Gopal Subramaniam. Good point. In such circumstances, we appoint. Dr. Justice D.Y. Chandrachud, former Chief Justice of India, to act as a mediator between the parties and resolve the disputes. Full point. The fees, etc., of the learned mediator shall be fixed in consultation with the parties. The learned mediator shall furnish his report at the earliest. Okay? Parties to appear before the learned mediator and proceed further. This matter for appropriate directions after 8 weeks. Okay? In the meantime, both the parties are directed to maintain status quo. If there are any proceedings between the parties, civil or criminal, those proceedings shall remain stayed till the report of the mediator is received. And further orders are passed by this. Okay?
Very well.
Sure, proceed.
Deeply obliged. Not just one more thing, my lord. There are certain civil cases not filed by respondent number 1, but by some other group company, my lord, against the petitioner.
We are sure now it will be resolved.
Very well, my lord.
Fine. Something, it was little distant.
Lordships have
Anyways.
my lord, acute discernment.
Anyways, that's it. Next time.
Deeply obliged.
नहीं, अपनों को spare. Rest of the matters, we will post it in the next week. We have a separate bench.
Lordship.
Any mention?
Item 44, service is incomplete vis-a-vis 2 respondents is concerned. So
A request you all have to make it to the.
in the meanwhile, I'll do that.
Your Lordship, I am mentioning item number 46, Your Lordship. It's an urgent matter, Your Lordship. NEET PG matter. Monday, Your Lordship. Lordship, top of the board will be.
Who is appearing for the other side?
Your Lordship, NB.
Who is appearing?
Meenal Sharma, Your Lordship.
Respondent, NBEMS Lordship,
This is the same matter where Mr. Rahul Kaushik.
Yes, Your Lordship. Yeah. Your Lordship, these are, Rahul Kaushik says is a connected matter.
Connect.
Main is the Aditi and others and.
We'll keep it on Tuesday, not Monday. Tuesday, top of the board.
Oblige, Your Lordship.
My lord, may I mention item number 36, my lord? It was related to the illegal arrest, my lord.
Illegal?
Arrest, my lord. Yes, my lord. Chinese woman has been arrested and 3-year-old child. Today the matter was listed, but it was not called.
You have served them?
Yes, my lord.
Who is appearing?
I'm being led by learned ASG, Ms. Bhati, Lordship.
But he has some instructions.
Yes, Lordship.
What are the instructions?
Previous order.
What are the instructions?
When, I'll inform her, she'll be here, Lordship. After lunch.
But after lunch, we are not assembling.
Maybe on Monday, Lordship.
You asked Ms. Bhatti to be here on Monday. Monday, chop off the board.
Yes, Lordship.
Monday.
May I have your lordships?
1 to
May I
10
have-
list.
Item number 1.
Obligement.
Pardon?
There's one matter, serial number 41. Would be taken up on 17th October, if it's convenient.
17th?
October. Or next Friday also, I have no problem.
17th October.
Or next Friday, whatever is convenient.
Your petition case.
Departments.
Department's petition. Okay, we'll fix it.
Obligement.
Will your lordship be item 37, my lord?
Yes, what do you want to mention?
My lord, item 37, can it be on 6th of October, my lord? I'll be coming to Delhi on that day, my lord.
Pardon?
Item 37, will be had on 6th of October, my lord?
6th of October?
Yes, my lord.
Okay, 6th October. Okay.
Obliged, my lord.